Good afternoon. This is Hap May with the Legal Play.
And I am Chelsea El-Azzi, Hap's associate. All right, Hap. So we're at the end of the year. Um,
Almost, yeah.
we're getting there. We're getting there. Yeah, there's a couple more weeks, and we are chugging along in this office. It's still pretty busy here. But coming towards the end of the year, we're looking at end of year wrap up and what are our thoughts on the landscape in 2025? What can we expect to what legal
Well,
changes and what's the legal landscape in
in particular,
2025?
we have a significant change in the federal government coming, and we have had a Democratic administration for 4 years, one that was poised to do some more regulatory, but I guess step deeper into the regulatory role in many areas: consumer finance, environment, employment. Things of those actually that employers and when we went to continuing legal education programs talked about these are the things that are likely to happen and how you're going to have to deal with the federal government on these various things or what you will and won't be able to do because of coming federal regulations and significant changes that I mean the election being a huge significant of that. So you're going to get a regime, a president and administration that is less likely to have the federal government regulate. In fact, deregulation was a major campaign theme. And we've seen that before. I mean, we've seen that with, when Ronald Reagan got elected, there was a great deal of deregulation that took place. And later on, other administrations have sort of added back a lot of regulations
Okay.
in the process. So that's a political change that we can expect.
So in terms of how that's going to affect, different spheres, we were talking before going before hitting record on this podcast about some of the areas that might be affected. You mentioned oil and gas and the
Yeah,
energy
I mean that,
sphere
and
being
that's
one of them.
and that's the attitude drill baby drill, which we've heard for years, but May Trump is repeating that, and I'm expecting that some of the environmental regulations that were proposed and some of them are actually put in place will be eased in the process. Also, the process of leasing federal lands for oil and gas production will probably be more liberalized, so it'll be easier for oil companies to strike a deal with the federal government to drill on federal lands. I'm not sure whether we're ready to open up the Gulf of Mexico for offshore drilling again. We'll see where that goes. But that's one of the things that since the BP Macondo event, I don't know, it must have been 12 years ago, something like that.
I remember.
Yeah, it's been fairly restrictive as what you can do
Okay.
offshore in waters for which the United States has jurisdiction. It would not surprise me at some point in time we need oil, and that opens up again. And perhaps technology has improved so that there's less risk. But I'm not sure that's likely to happen in the next 4 years. But other onshore oil and gas projects, I think we will see more activity and less federal regulation, less restriction, and a more drill baby drill attitude.
Okay. You also mentioned something about consumer finance and less
Consumer
regulation
consumer
there.
finance, yes, and I mean for some reason I visualize Elizabeth Warren in this because she was a big promoter, during the Obama administration and later in the United States Senate for a series of regulatory requirements for consumer finance, for banks and other things. They were coming out with things like restrictions on fares that could be charged or items that could be charged by airlines or fees that could be charged by banks and a whole bunch of other consumer type transactions. And while I expect that the United States federal government is not going to completely walk away from the regulatory environment there, some of the things they were talking about doing, the proposals, will be put on the shelf.
Such
during Trump's
as,
administration.
what would be one example of that?
Well, I mean, I'm not haven't delved deep into this, but there were a series of restrictions placed on banks, bank overcharges for checks, for fees that could be charged, late fees, and other things like that, and a whole bunch of things that could not be charged for airline and things like that, and I think some of the proposals that the Biden administration were proposing will not be pushed as hard. I mean, there'll be some softer approach toward regulating those type of fees and things,
Okay.
industries and stuff like that. And whether that's right or wrong, that's just what I expect in the process. And then, I fully expect that at some point in time we'll have another Democratic administration, and there'll be another push to get, some of those fees put it back as the pendulum swings back and forth. But I think for the next 4 years, regulation in that consumer area will not be as aggressive as it would have been had somebody else been elected.
Okay. Other things is, I think you mentioned it was the FTC.
The FTC it regulates a lot of trade type things, and they were taking.
What does FCC stand for again?
Federal Trade Commission.
Yeah, okay.
And they, along with some other government policy makers, were looking at employment relationships and covenants not to compete. Which to give the background on that, a lot in a couple of situations where an employee is hired and been given access to customers and proprietary information in the function of his job, the employer would be reluctant to do so if that person could just take all that information and all those contacts and move it to one of the competitors, or basically go into business, employee go into business for herself in the process. So they have agreements they call covenants not to compete. They also are very common where you have a business owner selling the business to a old owner selling to new owner, and new owner wants to make sure that the old owner doesn't just move across the street and start doing the same thing with the same customers, the same information. So those are the reasons we have covenants not to compete. There is some concern, I mean, legitimate concern that becomes too restrictive. And so both state and now federal lawmakers and regulators have tried to limit what can be done if you have a common type of job that doesn't have any unique skill or require any unique use of proprietary information. Then you're generally not allowed to do that. You get a lot of differences. Some states are really open that you can it's difficult for an employer to stop somebody from moving around and taking information and clients with them. Other states, it's more restrictive. The Federal Trade Commission during the Biden administration was looking seriously at adopting regulations that would have severely restricted an employer's ability to impose those kind of restrictions on an employee. And there's some court action with regard to that as to how much authority the federal government has.
Okay, I was gonna say this doesn't sound right, because my understanding of covenants not to compete is it's an agreement between private parties in private businesses, but you're talking about this is covenant to compete in private business
and employment relations. Yeah, and the Fed, they're worse. Even the most aggressive proposals from the Democrat administration would still allow new buyer to protect himself from the old company owner from selling him the business and then competing. Where they were really trying to step in was in the employer-employee relationship and limiting the extent to which an employer can pose restrictions and have an agreement with the employee.
The employee that would be leaving.
Yes,
and potentially taking trade secrets, proprietary information, specialized skill,
customer relationships.
Which probably shouldn't do that anyway.
Well, I mean, other than that's
No,
that's not a
specialized
lot.
skills is one thing. That's mine. But yeah, yeah. If you certain things I can kind of understand, but I don't understand why how is it that the federal government would be able to say we can regulate that? I
And
mean,
are those agreements enforceable? It's, I mean, there's some extreme cases where
see, but then that makes me question whether or not we need to be having a conversation on how are agreements enforceable, period, because this is a type of an agreement.
this is the type of an agreement that state law has traditionally regulated. Some states saying, you know, you're limited as how you do that. Other states saying no, an employer and employee can make a relationship, can make an agreement, and the both the employer and
And
employee
whatever they sign, they
right.
should understand what they're signing, and that should be binding. I guess if it gets too
It gets
restrictive,
too
then
restrictive. If
it's
it gets too restrictive, then the employee can't get another job.
yeah, okay, I
So
see
it's
that.
basically,
I see that.
you're selling widgets in the state of Texas. And I say you can't sell, you know, consumer products in the state of Texas. And he's a salesman. He wants to sell consumer products. His family lives here. I mean, he's basically becomes an indentured servant at that point in time
Yeah,
because he can't go get a job somewhere else where he can continue to function. So there are legitimate reasons not to say that
it shouldn't be
an
regulated at
employer
all.
is unlimited and can basically require somebody to spend the rest of their career working for them because the covenant is so tight. So there's reason to do that. At the same point in time, the federal government, arguably, the federal government, in the current Biden administration was perhaps going too aggressively in that, saying basically it's going to be very difficult for an employer to have a covenant that's enforceable.
Yeah.
And in which case, there would be some people reluctant to hire.
Yeah, yeah, yeah. I was
I
gonna say
would
there's
be,
gotta be some promise not to take your customer list when you
and
go,
that's yeah, that's
especially if it's existing lists that were there before you got
right.
there.
Right. You're sounding more conservative than you usually do.
I think I actually flipped.
It wasn't.
Flipped both ways in like the last.
When we're talking about the consumer side of it, I mean, I can see you leaning to the left. Now I see you sort of leaning to the right in the process. But that's
Opening up the whole floor to discussion.
I guess my point to this whole discussion is it's less likely that the federal government steps into that arena and allows the states to continue to regulate them however the states
Well,
choose
which
to
is, I
regulate.
think, fair because even if, let's say, it wasn't regulated and it's agreements, contracts, if there's a dispute over its interpretation and whether or not it should be binding, you would take that to the court
In the state,
in the state.
state law, yeah.
And the state law would govern
yeah.
how that would be interpreted and
But
whether or not it's enforceable, et cetera, et cetera.
I guess the argument against that is there's just, I mean, there's absolutely no uniformity. Some states did this,
Right, okay.
Texas is, has one, California has another, which on most areas of law, Texas has one point of view and California has another. But
God, yeah, but now I think
one,
we're getting into the philosophy of just what builds the United States. I mean, that's the whole point is all the states are different, slightly different in their laws and the way they do things.
It's gotten more difficult because what state do you work in? Well, where my laptop is, that's where I'm working, so that and employment rate, all of that stuff is the law has to kind of review, kind of geography, in ways that they didn't have to before. And employment relations is one of those.
Boy, and I think if you've been listening into this podcast long enough for like maybe a tip, something to take away from this is if you're getting ready to enter into an employment agreement that has a covenant not to compete, maybe look at the governing law, what jurisdiction in the governing law would potentially be binding on you.
And usually when we as lawyers deal with these things, we deal with the employer during the hiring process or the employee after he's left and says, well, what can I do? And try to figure that out. So
but I guess a tip before you sign, consider all the provisions and even the miscellaneous ones that you think those are just boilerplates. They're in every contract. I guess take a look at jurisdiction. And if you decide you don't want to litigate in Texas, if you think, well, but I'm actually working out of Colorado, I don't really maybe have that discussion.
Yeah,
maybe have that discussion with
there
your
might
employer, see if that there's some wiggle room there.
well, that's yes, and employers. I mean, be aware of all these things too. I mean, if you want to try to protect your customer list and other items that you would have to give an employee access to, stay tuned. This is an area of the law that is getting trickier.
Okay.
And one other thing to kind of close out this, in addition to the changing of the administration and the shift, to the right on a lot of these regulatory, situations, is the Supreme Court struck down what was called the Chevron Doctrine, which is Chevron Doctrine said that if a regulatory agency has propounded a regulation or a rule
Or an
well, no,
interpretation.
its interpretation of its rules should be given deference by the courts. And that was, for about 40 years, that was the role, and the Supreme Court has struck that down. And now it is not the courts will interpret regulations without giving deference or preference to what the regulatory agency interprets it, making it more difficult to draft and enforce regulations. So the power of the federal government to regulate is still there, but it's not as strong as it used to be.
Well, I mean, there is another. I remember it being Chevron and Skidmore. I don't know if Skidmore's fresh in your brain, but there was. I mean, I understood Chevron as if it's a federal agency and this is their interpretation, it's reasonable. We're just going to go with it. We're just going to go ahead and give deference to the agency's interpretation. Whereas I think maybe Skidmore was before Chevron came into the. I don't honestly can't remember the timeline of things, but my understanding is that Chevron wasn't there to revert to Skidmore, and though there were these levels of is it reasonable? How long has this agency been doing it? How much experience do they have in the area? And there were all of these like check boxes for how much deference to give the agency's opinion and interpretation.
And now, I mean, under present interpretation of the current Supreme Court situation, there's no deference. I mean, it's you read the regulation, and the judge gets to interpret it without saying, one side gets to sort of tell me what they think it means, and I'm stuck with it.
Okay.
So
interesting.
The relationship between the federal government and our economy is constantly changing. Right now, the shift is away from federal involvement. So we expect to see less of it, or have it have less impact than we might have otherwise seen in a different environment.
Okay.
This is Hap May with Legal Play.
Thanks, Hap.